Welcome, everybody. I hope that you're hearing and seeing us well. We'll have a tech person check that out. But I wanted to welcome you to our special edition of the Art of Advocacy show. Today we have a wonderful guest with us, the winning attorney, Jack Robinson, from the recent Supreme Court case, Endrew F versus Douglas County. So we'll be starting in just a minute with your live questions. Feel free to type those in the comment box. And I wanted to just say that at the beginning, Jack and I were talking before we came live. Both of us were working together on a task force a few years ago in Colorado when the state regulations for special education were being rewritten. So I told Jack it's fun to be back live, even though we're in different states now. So it's pretty amazing. Cross your fingers that we won't have any technology glitches. But what we'll do today is Jack will give us the background on the student and his family, then give us the highlights of the decision. Throughout the show, we'll be answering live questions, so just type those in as you think of them. And before we get started, I thought it would be helpful if Jack could share a story of where he was and what he was doing when he found out about the decision on March 22nd. Welcome, Jack.
Yeah, thank you, Charmaine. It's great to be here. Thanks for doing this. And so I was, so as you said, the decision came out the morning of March 22nd, and I think it caught everybody, certainly me, by surprise. And I didn't even think about checking, checking the internet or checking my computer when I first came into the office, and I got a phone call on my cell phone from one of my co-counsel, Brian Wolfman, who's now at Georgetown University Law Center, who was just ecstatic, saying, we won, but he was, just had seen it briefly on his phone, and just had seen that the Supreme Court had ruled in our favor. He didn't know about any of the details. Just had seen it briefly.
Sorry, I'm muting my phone.
Okay, so anyway, I quickly got onto my computer and was reading the decision, and about halfway through reading the decision, of course, we're 2 hours later than Washington, D.C. is, that I started getting these emails from reporters who were watching the confirmation hearing of Judge Neil Gorsuch that was going on across the street from the U.S. Supreme Court. And apparently Senator Durbin they had gotten copies of the decision, and Senator Durbin, anyway, was taking the lead in sort of cross-examining, questioning Judge Gorsuch about this decision, because this decision was significant in many respects, but one important respect was that the Endrew F Supreme Court had reversed and rejected this substantive standard for a free, appropriate public education that was first articulated by Judge Gorsuch in this case that I actually was the attorney on in this Thompson R2J School District versus Luke P, where in that case we had won at all stages until the 10th Circuit, until Judge Gorsuch reversed and articulated this merely more than de minimis standard, saying that because the student in Luke P had, there's some evidence of some progress on some goal, that was sufficient for the free, appropriate public education, reversed, and there that decision stood until March 22nd when Supreme Court reversed that. So anyway, quite the momentous day.
Oh, I bet. I know, and I was watching the confirmation hearings, and it was interesting to hear the questions, and that they had already gotten the decision just, as quickly as possible, I guess. But so there's lots of implications of the decision. So not only for students, but in other aspects too of our country. So this will all be interesting. But if you could just kind of give a brief synopsis of what it was like for Drew when he was in elementary school.
Sure. So I'm sure, you and a lot of parents and advocates can relate that, Drew, he's a child with autism. He has ADHD. He was, pretty much nonverbal at the time. And we're talking about, and he was in Douglas County School District for his entire sort of educational career until the parents removed him and placed him at Firefly Autism Home. But, in those earlier years, maybe based upon the parents' expectations, things were going okay. But beginning in second grade, say, the parents noticed, and the school staff noticed too, that Drew's behaviors began to deteriorate as far as his ability to attend to school. He had certain phobias, certain sort of OCD symptoms, and I don't know, beginning in second grade, it just became more difficult for him. And, the school district, as all school districts would do, would develop IEPs year after year. And, the focus more was on figuring out, trying to figure out Drew's behaviors unsuccessfully, as opposed to putting any real effort into providing him an education or dealing with, these IEP goals and objectives. So, the evidence really was that from year to year, the IEP goals, the majority of them were abandoned, some of which, some of those that stuck around were really unchanged. And some goals, counting coins or recognizing coins, the objectives, the words of the objectives would be changed a little bit. But anyway, the IEPs virtually were unchanged from year to year, certainly in the hours of service. But his behaviors were deteriorating. His communication was regressing. Socialization, the parents saw no improvement whatsoever, and they're getting sort of desperate. And, Drew, on a couple of occasions, had actually eloped from the classroom, had eloped from school unnoticed. And the parents, towards I think it was the spring of 2010, basically had just had it. They were very involved with the school district, but, despite their efforts, nothing was changing, and they believed that Drew was not safe at school, and they couldn't keep him safe. So they decided to remove him from school and place him at Firefly. They asked the school district to pay for it. They refused, and so Drew spent the summer basically at Firefly, where Firefly immediately did a functional behavioral assessment, developed a fairly comprehensive behavior support plan, identified those target behaviors that interfered with Drew's ability to just access education. He wasn't aggressive, he wasn't violent, but he had certain, maladaptive behaviors, problem behaviors that interfered with his ability to really learn. And Firefly targeted those. They developed plans to address those, and within a very short order, Drew was making progress. The behaviors weren't eliminated right away, but he's making progress. And so in the fall of 2010, parents contacted the school district and basically said, here, we've seen all this progress over the summer. It's a new year. Can we basically have an IEP meeting to learn from what Firefly had been able to do, where Drew was at in November of 2010, as opposed to the spring of 2010. And so an IEP meeting was conducted at Firefly. They had Firefly people there, Douglas County School District people there, the parents were there, and instead of learning anything from what Firefly did, the school district basically presented the same IEP that was presented in April of 2010. There was no new behavior support plan. The behavior support plan that they attached to the IEP was, I think, 2 years old, identical to a draft behavior support plan from 2009. And so the parents were like, all right, you're not offering us anything that we had already rejected back in the spring of 2010. We're going to keep him here. And that's when they contacted me.
So I don't know. I guess sometimes I think things are surprising, and then sometimes I think, no, this happens a lot. But yeah, it's disappointing that the school district never took they had the opportunity. They chose not to do a functional behavior assessment or write, an individualized behavior plan. But I think what's helpful is that parents know that there are steps that they can take when they reach roadblocks. And so one of those is to contact someone like yourself, Jack, who practices special education law. And, you mentioned that this was happening in 2010. So now we know 7 years later. So it's not a quick process, but if you could maybe spend a little bit of time just talking about the highlights of this unanimous decision that we got in March.
Sure. So I think, the first highlight, the most important, well, not the most important aspect of the case, but certainly a very important aspect of the case is that the Supreme Court in Endrew F rejected this notion. It's not even a notion, basically rejected this case law that had developed after that Rowley decision in 1982. And Rowley, just as a refresher, was the very first Supreme Court case to really interpret the IDEA and sort of grapple with this notion of a free, appropriate public education. And in Endrew F, the very first paragraph of the decision said, in Rowley, all we decided was that the IDEA, as it's known now, provides a substantive educational requirement, which does two things. It rejects the school district's argument that the IDEA is nothing more than a checklist of procedures and that there is no substantive educational requirement. But two, saying that Rowley never meant to establish any substantive standard for a FAPE, and which, again, this is how this case came about, is that since 1982, all of these circuit courts, U.S. district courts had developed these various standards for what equated to a free, appropriate public education. I'm sure you've heard this meaningful educational benefit standard or the some educational benefit standard or something in between. The Supreme Court here said, we never meant to, there is no such thing as a some educational benefit standard or a meaningful educational benefit standard. We didn't do that in Rowley, but we are establishing a standard now. So that's one thing. The second thing is the Supreme Court's sound rejection of the 10th Circuit's merely more than de minimis standard. That was, as I believe we talked about earlier, was basically created by the 10th Circuit in that Thompson versus Luke P. case that Judge Gorsuch was the author of, where he took this notion of some educational benefit and then added this merely more than de minimis, and then further explained that merely more than de minimis is equated to whether the child is making some progress on some goal, and left it at that, and said because Luke P. was making some progress, didn't define what that was, didn't identify what goal he was making some progress in, but said because the child's making some progress on some goal, that's all the IDEA requires, judgment in favor of the school district. And that's been the law in the 10th Circuit, and other circuits have adopted that standard as well over the last, 8-9 years. And so Endrew F. case came about, and I thought that it was the perfect case to challenge that, because in this case there was no evidence of any progress. There's no progress reports ever given to the parents. There was no evidence in the IEP themselves, where they have a little section for progress. There's a couple of IEPs that said, Drew can really do it if he tries, or I don't know, something meaningless like that. But there was no measurable progress to show that on day one he was doing, he had 10 sight words, and at the end of the year he had 20 sight words. There's no progress like that. So we thought, here, if there's any case to show that there's no merely more than de minimis or no progress, this was it. And Of course, we lost at each stage, but the 10th Circuit, applying that merely more than de minimis standard, did articulate this is without question a close case. It recognized that there's no real evidence of progress, but because some of the goals had changed over the years, the ones that weren't rejected, that is, the court found that that's enough. And the Supreme Court took that and soundly rejected this notion of merely more than de minimis. And, a big takeaway from the decision is the Supreme Court saying this merely more than de minimis standard is no education at all. And that they adopted or established a standard that was markedly more demanding than that merely more than de minimis standard. So that was a big deal.
Right.
Yeah.
And so do you know, and I was going to look up and I didn't check, but so that merely de minimis standard is what people in the 10th Circuit were having to use ever since that Luke P decision. But do you know if other circuits use merely de minimis, or was that just pretty much 10th Circuit?
So, on that and that's an issue that came up at the oral argument in this case. Judge Alito was asking the counsel for the school district as to where did this more than de minimis come from. And hold on, let me just get out of that. Where did this more than de minimis come from? And didn't really know the answer to that question. And Judge Ginsburg, I believe, jumped in with not just more than de minimis, where did this merely more than de minimis come from? And, based upon my research, it came from Judge Gorsuch. There was a decision back in 1988 called Polk versus Susquehanna Community School District that's in the 3rd Circuit that used the words more than de minimis, but used the words more than de minimis in a way that was meant to that a FAPE had to be more substantial educational benefit, more than de minimis being substantial educational benefit, and this 3rd Circuit established this higher meaningful educational benefit standard. And after that, other courts started picking up on this notion of more than de minimis. But again, more than de minimis being open-ended as opposed to there being a cap on educational benefit. And so in the 10th Circuit, and not that, say Judge Gorsuch or the 10th Circuit is bound by any other precedent than its own or the Supreme Court, but in the Luke P case, based upon my legal research, I'm fairly close to it, Judge Gorsuch or the 10th Circuit was the first court to establish this merely more than de minimis standard. And in addition to using these words merely more than de minimis, because I think, maybe people will argue, well, more than merely de minimis or more than de minimis, merely more than de minimis, aren't those just words? But, we as lawyers choose words very carefully, word placement very carefully. But in addition to establishing this merely more than de minimis standard, the 10th Circuit and Luke P went on to translate that standard into the some progress standard, that as long as the child is making some progress on some goal, 1 goal out of 10, 2 goals out of 10, minimal progress on 1 goal out of 10, that is enough to satisfy this FAPE standard. And that is what the Endrew F or the Supreme Court in Endrew F rejected.
So that is such good news, because I think parents know now that they need to be able to have higher expectations for their child when they're writing, with the team, that individualized IEP. I think so many times people forget what that I stands for in IEP. But now hopefully we'll have some, like I said, higher expectations for students. But I know in the Endrew F decision, the Supreme Court said that they weren't going to establish any kind of a formula to figure out, what kind of meaningful or educational benefit would have to be there, but instead that they were setting a standard. So do you want to talk about, they rejected the 10th Circuit's standard, and what did the standard become now under the Endrew F case?
Right. So just so I don't get it wrong, the Supreme Court established a standard, as you said, which I think is good, given the uniqueness of every child with or without disabilities, or with or without IEPs, established a standard, not a formula. You don't input these integers and you get spit out this calculation as to what equates to a free appropriate public education. So we have a standard. And obviously standards are open to interpretation, but they must be applied with fidelity. And the Supreme Court standard is that a school district must offer an IEP reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And so again, the decision goes through it and says what reasonably calculated means, what appropriate progress is tied to, and in light of unique circumstances or potential. And so we have a standard, but then the court goes on to expound on that standard by reinforcing this notion that merely more than de minimis, the sort of the standard, certainly in the 10th Circuit, and that's been adopted by another or a number of other circuits, is no standard at all. That does not provide an education at all, and that the standard that they've adopted is markedly more demanding than that, and that for children who are not educated all of the time in the general education classroom or pursuant to the standard state standards or general education curriculum, that the goals have to be appropriately ambitious, that there have to be challenging goals, that they have to make appropriate progress in light of their circumstances, which to me is very expansive.
Right. So I think for parents that are listening today and that will probably be watching the replay too, but for parents, I'm trying to think of some, little nuggets that we could give them. One of the things that I read, and I'm not an attorney, so I can't give any legal interpretation or advice, but so I'm going to say something and then double check with Jack to make sure that's accurate. But it sounds to me from reading the decision that there is this emphasis on more than just this checklist for progress reports, but that it be data driven, that, the strategies that teachers are using are peer reviewed ones. So can parents be expecting to have that IEP team show them actual data for progress and be using peer-reviewed research-based strategies?
Yeah, I think that's exactly right. I think at the last, on the last page of the decision, the second to last paragraph, the Supreme Court does say that these IEP decisions, what is reasonably calculated to enable the child to make appropriate progress in light of the child's unique circumstances, is data driven. It is per the expertise and exercise of reasonable judgment by school officials with the parents as equal IEP team members. But what that means is that, and in my experience and maybe your experience, the school district can't just come to the table and say, trust us, or, we have a bright, beautiful room. We like to dance. We like to have fun. Come and see it. Trust us. But rather, this IEP is not just a form. It's not just a process that we just go through lightly, but rather the IEP has to provide those components that can show, based, as you said, on peer-reviewed research, based upon the exercise of expertise and judgment, that this is reasonably calculated, again, to provide appropriate progress in light of the child's unique circumstances. And they have to stand by that. And if it's not included in the IEP, then they lose. And just another, sort of quick comment about what parents, I think, can bring to the table. What a very important facet of this decision to me is is not what necessarily is even said in the decision, or whether parents even know about this decision. But I do think that it changes the landscape of sort of this IEP process, and that, granted, people are going to have their different interpretations about it, but at the end of the day, the Supreme Court has removed this notion that the parents don't have any substantive educational rights, or the child does, in that the parents are walking into the meeting or IEP meeting as I don't know, as a more equal partner in this endeavor than they did before, which I think is transformational.
Right. And I think before I heard you make a comment that it levels the playing field a bit more for parents now.
Yeah. And because I do think that, again, I've said this before, but that clearly, I mean, school districts try to aim high. They, maybe for the vast majority of the time, they do what is right, and they have the right notion about what is necessary to educate this child, and they develop an IEP in conformance with that, and everything goes great, but not all the time. And,
right.
This does require the school districts not to just have aspirations of aiming high, but rather has a minimum requirement that they aim high for all children, regardless of whether the parents are at the IEP team meeting or not, whether the parents are out of the equation, whether they have an advocate, whether they have an attorney. We're all playing by the same high standards. And again, too, that this is not something that the school district is choosing to do because it wants to do, be benevolent or whatever, but rather this is what the IDEA requires. And this is the minimum standard, and hopefully they'll aim higher than what this is even required to do.
Right. And I think we do have some circuits now, especially on the East Coast, that have higher standards than some of the other circuit courts. But from my understanding, they'll still be able to maintain their higher standards, according to their state or circuit decisions. So is that true, that there won't be, any problems with that?
Right. And I do. Right. I don't think that this decision speaks to that standard, or that, say, higher standard. In the Third Circuit or Sixth Circuit, they have what's called a meaningful educational benefit standard, and that's interpreted merely, my understanding, I haven't done a lot of research regarding the Sixth and Third Circuit standards other than from this legal perspective, but typically meaningful educational benefit standard is articulated in a way that it's contrary to this minimal some educational benefit standard, merely more than de minimis. And that's exactly what this decision does. Rips out the bottom, rips out this vanishingly low standard, and saying that this standard is markedly more demanding, and you have to adhere to it. And I think that's exactly what the meaningful educational benefit standard has done. And now the vast majority of circuits are going to have to figure out how to apply this.
Oh, exactly. And I think back to some of the situations that IEP meetings I've been at as an advocate. And one of the things that I've noticed is that sometimes the school members of the IEP team, it seems like they almost want to set low expectations in the goals, because then they can show that progress is made. They can also show that having an OT for only 30 minutes a week will, give that student opportunity to make progress. So I don't know if you have any tips for parents, but I like to kind of connect those dots and make sure that, the goal is appropriate for the student, then also to make sure that the time, that the services are going to be provided are going to actually give the student a chance to make some, substantive progress on his goals.
Right. I think that's critical. So say for children, who get most of their education in the regular education classroom. Well, I guess the way that I would approach that question or that issue is that for the vast majority of kids with IEPs, that their goals and objectives and their educational program is going to be geared towards obtaining that level of educational benefit where they can advance from grade to grade based upon those established state standards, right? I mean, that the barriers to their education are going to be removed or remediated or addressed such that they are, in essence, learning like every other typical child is learning without an IEP. And that includes behavior barriers, learning differences, barriers, social emotional barriers, whatever, that they are achieving that same grade level achievement as every other eighth grader. But for the other children who, with IEPs that maybe don't have that potential or their circumstances don't allow them to achieve that level of grade level achievement, that the goals and objectives are still in line with that. And well, for example, I mean, I've dealt with, even when I'm in the room, and I think it's absurd and you try to argue around it, but certain school districts, staff members are of the mind that, well, let's start with like 3 goals. Let's not go crazy here. Let's start with 3 goals, the 3 main sort of issues. And regardless, like in Drew's case, that behavior is a major issue. There's no goals around behavior. And Drew didn't even really have a behavior intervention plan, but rather here, he has a communication, expressive language delay. So let's have a language goal where he says hi to the teacher in the morning, or let's have a reading goal, but let's only have a couple because, we want to be able to take data and we don't want to overwhelm him. That is not in line with this decision. He's not making, say, grade level advancement on even, modified standards, which, where's, science, there's social studies, there's math, there's, all facets of an education that now have to be addressed in an IEP.
Right. And I think that's the important thing too, is for parents to understand that they need to have that conversation either, as a pre kind of meeting where they talk about what their priorities are for their child for the next year, or certainly it has to be also repeated during the IEP meeting. We know it has to be written in the IEP in order for, the parent to expect that there be accountability from the district. But hopefully we will see different conversations around the table now. And I think that's the transformational part that I'm looking forward to. Yael had posted in chat, we had a question from Debbie, and she said, how does it work with OHI kids? Very confusing. She said that she had heard that they were going to cut kids with OHI out of IEPs. So if you could respond to that one, Jack.
That's news to me.
Yeah.
Other health impairment is, at least in Colorado, and I know, in the IDEA, that it's an established eligibility category that encompasses many, many different things. So I'm not really sure. I haven't heard anything with regard to other health impairment or how anything might affect that.
Yeah, because the 13 categories are in IDEA. So if they were it seems like if they would do something that would eliminate that, they would have to go through the Congress. And speaking of, just a side note, so do you know, because we haven't had IDEA reauthorized since, 2004?
Right.
So do you know, will that ever become reauthorized, or have you heard anything?
Yeah, no, I haven't heard anything, but I guess the difficulty in tackling the Affordable Care Act, and I guess taxes are on the horizon. I'd be surprised if they tackle reauthorizing or amending the Individuals with Disabilities Education Act. But even then, that would be a long sort of public
Right.
process that all stakeholders hopefully would have a say in.
Right. So maybe, Debbie, you could type in the comments what state you're from and where you heard about the possible cuts to kids under that OHI category, because I'm not sure that I've heard of that. So another question that I had from a parent that wrote in, Jack, was, is there a way to predict how maybe some school districts are going to interpret this decision? And is there a way for parents to be prepared for when they come to the IEP meeting, how they can, kind of include some of the verbiage or what would be helpful for them? But how do you think districts are going to interpret this decision?
Right. Well, I do think that there's going to be, at the outset, I think there's going to be a flurry of confusion, if you will, or a flurry of maybe litigation, trying to figure out, all right, what does this mean? How does this apply on the ground? And like we said before, this is a standard. It's not a formula. But I do think that given a fair amount of the language in this decision, very forceful language, that the school districts, I believe, will be hesitant to, poo-poo it in any way and say, well, this is what we're doing anyway. And so I think it's going to take their attention, but too, I think from a practical perspective for parents, I do think that, you go back to some of the provisions of the IDEA already, and in particular, a parent's right to request an independent educational evaluation after the school districts performed their evaluation, to me, I think is going to be a more critical component because this appropriate progress in light of a child's unique circumstances or a child's circumstances, I think the parent will want to have a very solid knowledge or have this trust level that they know what progress to expect and also what the child's, say, potential is. And that may differ from the school districts, and not necessarily to rely upon what the school district says here. We know your son or daughter, here's what we do, here's what, I don't know, that the parent is not an engaged participant with its own sort of independent expertise.
Right. Yeah, because I think, parents, I think it's always a good practice to ask for the draft IEP ahead of time and to look at what they've written and their present levels of performance. Sometimes you see those comments like, oh, he's got a nice smile, he likes music class, and it's like, okay, but tell me how he did on last year's goals and, some data about where he's, starting for his baseline. So parents, I think, just sometimes need that confidence that it's okay to speak up and ask questions and not just to, think that they're the experts and that everything that they propose to you is going to be appropriate for your child.
Right. And I think a good example, maybe say a child with dyslexia that what progress with regard to reading or writing or even, with regard to math, what reasonable progress is to be expected. And two, in light of the child's circumstances, is what peer research-based services and supports are going to be provided to that child in the IEP that's reasonably calculated to enable that child to make that progress. And I think that this decision gives parents leverage to demand specific interventions for, to make specific progress that did not exist, at least in the 10th Circuit or the majority of circuits before this decision.
Right. And we have a couple other live questions here. So let me get to CJ is saying that she agrees that the standards are set low in goals and objectives so that progress can't help but occur. she said, do you see more due process cases coming in light of this case now?
Yeah, I think, like I said before, I mean, my expectation is that there will be some greater sort of flurry of activity, whether it makes its way to a due process hearing or more parents feel empowered to challenge the school district based upon this new standard, whether that gets resolved through mediation or the resolution process. But I do think that parents are going to feel more empowered. School districts are going to feel less certain as to where their accountability lies, and I think naturally that can lead to some fleshing out as to what this all means. Because, as you well know, these are very important issues, and it's parents that I sort of represent. There is this sense of urgency, right? That we want to get this resolved now, and I think school districts have the tendency naturally to push the can down the road. That third grade will be a lot different than fourth grade, or you're going on to middle school. We have a whole different suite of opportunities in middle school than we do here in elementary school. Same thing with high school, and there's just this tendency of just delay and delay. Let's tweak this. Let's add a shadow person or a para or whatever. And so I do think that parents, will hopefully say, let's get this resolved, now based upon this new standard, and get this resolved.
Right. Because every day counts so much for our kids that, we can't really delay without them losing out. Another question I had from a parent was, because this decision came down March 22nd, so does this now become effective March 22nd going forward? Are there any, ways that you can use, say a decision, an IEP that you had, decided in January, February? Is it retroactive at all?
Yeah, I mean, the way that I read that decision is that there was no standard before. I mean, there are standards in the 10th Circuit, but not 10th Circuit. There were these standards in the various circuits purely based upon, or primarily based upon, this Rowley decision. And the Supreme Court in Endrew F said Rowley never stood for that. The only thing Rowley stood for was that the IDEA requires a substantive educational requirement. And in the circumstances of that particular case, where Amy Rowley had an IEP that provided, substantial special education services, and she was making excellent progress in her classes, the Supreme Court says, we're not setting a standard, but the facts of this case, this is good enough to satisfy the IDEA requirements. So, long way of saying, I do believe that pending cases, I mean, I know that I have a number of cases in, say, the U.S. District Court, and one that's, waiting a decision from the Office of Administrative Courts is that I've filed supplemental authority saying, here's this new case. You now have to judge this, the facts of this case based upon this new standard, even though a lower court or had applied a different standard. And I know I've already seen 2 or 3 cases that have been remanded back to lower courts saying, hey, look, the facts of this case were, or the court had applied this different standard. Supreme Court has articulated this new standard. So, court, you need to apply this new standard to that facts and see if you come up with the same decision or not. And I think that applies to IEPs that are in existence, that a parent might be satisfied with, or not satisfied, but their attorney, their advocate, or whatever, they might look at that IEP and say, well, based upon the law in this circuit, this probably passed muster, so I'm not going to bother making noise about it because the standard is so low. I don't really have any rights, as opposed to the parent, the advocate, the attorney might look at that IEP and say, wait a second, I had concerns about it before, but man, this surely does not pass muster under this markedly more demanding standard.
Right. And so for parents, I wanted to mention that I'm putting together this free ebook with just kind of like a friendly guide to the Endrew F decision and giving parents some tips on how they might use that. So if a parent is viewing now or watching in the replay and you'd like to have that free ebook, just type in the comments yes, and I'll make sure I give you the link for that. We had a couple other questions. So let's see. Tatiana asked, or she said, we are dealing with same issues, low expectations for the last 3 years, very little or no progress. They blame his disability and not the IEP. They don't recognize his potential. So then she went on to ask, what do I say? How do I make them understand our point of view? And I guess her kids have severe dyslexia. So, yeah, when the district is playing the blame game and saying it's because of the disability, I mean, yeah, that's why he's supposed to be getting, specialized instruction because of the disability. But what could a parent do when she just feels like, she goes to these meetings and doesn't get her point of view across to them?
Right. Well, in my mind, what I tell my clients, the first thing is to know exactly what you want. That what you want to achieve, what your I use the word, what your magic wand is, whether that's a rate of progress, whether that is a challenging goal, whether that's a specific type of service or it's a placement or whatever, is to be. It's one thing to know what's broken, or it's one thing to know, well, that goal, I believe, is too low or it's inappropriate, but that the school district is just going to hang tight on that and say, well, we believe it's appropriate. And then it becomes incumbent upon the parent to articulate to the school district or the IEP team, I should say, what an appropriate goal would be, say, or what appropriate rate of progress would be, or what, specific services are necessary to make measurable progress or appropriate progress towards those goals. And this, and if the parent doesn't have the answer to that, to say, hey, I have a goal written out right here that I believe my child can achieve in this school year, then, I always flip back to that independent educational evaluation, is to get that information from an educational expert and say, what should my expectations for my child be? Yes, they have this, say, disability or this learning difference or whatever, but what peer-reviewed research is out there that allow my child to approach his or her potential? And there are those experts out there that can say, here's the potential, here are the circumstances, here are recommendations, here are, let's help you draft goals and objectives. And then I do think that there's enough language in this decision to make to force the school district to adopt that. And if they refuse to adopt that, the last page of this decision anyway requires the school district to bring their expertise and their judgment to bear to say, here's why you're wrong. It can't be just, thanks but no thanks, or thanks for sharing that with us, but we're going to draft our IEP based on this. But rather, they do have to tell the parents, whether it's through a prior written notice or it's in the meeting minutes or it's in there somewhere, is to say, here's why we're right, here's why you're wrong. But I do think, my point being that really the parents have to come to the table with what they believe is required, because otherwise they leave it in the hands of the school district to do what they believe is right.
Right, and I think especially if your child has dyslexia, there is so much research-based strategies that are recommended for students with dyslexia. So I think it would be hard-pressed for the district not to choose. And I know they don't like to say the name of the program in the IEP, but, you can describe the research-based multisensory approach to reading and have that description in the IEP. And yeah, I think your suggestion for the independent education evaluations are really helpful, especially if you go to somebody who will not only do the assessments, but have some pertinent recommendations that can be implemented in a school environment. And, sometimes you can even ask the person who did the IEE to be on the phone or attend the IEP meeting with you. And I'm sure, Jack, when you appear at IEP meetings, when parents have somebody else with them, there seems to be a little bit better listening on the part of the district.
Yeah. And following on that, I don't know, just thinking about dyslexia, and it's true with autism, it's probably true with a number of different, say, learning differences or learning disabilities that, there's nowhere in the IDEA that says that the IEP cannot include a methodology or approach or a technique. You hear school districts all the time, and I deal with it all the time. I have a case right now in front of the U.S. District Court sort of on this issue of, a school district saying, well, it's our practice or it's the law. We don't have to put the methodology in the IEP. It's like, well, why not? If somebody's saying, say, ABA is applied behavior analysis, this is what we do at home. We've seen progress. You're going to use ABA in the classroom. It's recognized. ABA therapists say is going to be supervised by a BCBA. There's nothing, illegal or anything to put those words in the service delivery statement. The parent knows exactly what's being provided. And the same with dyslexia. If, it's established or it's acknowledged that this child makes progress using Orton Gillingham, or whether it's Wilson or Barton or whatever it is, I believe that should be in the IEP, so everybody's clear. Right. And maybe it's like, well, we're using Barton, but we're going to move over to Wilson or whatever it is. I'm not familiar enough with those, but to say this is what our staff are trained in. We have these materials available. This is proven successful for this child, and this is what we're going to implement, not some other whole language approach or whatever. And so this I think it's a fallacy to take that position that we cannot write this into the service delivery statement. Same with paras, the school district, well, adult support or adult supervision or whatever. We will never write in one-on-one para support. Like, well, that's what the child needs for safety reasons, for educational reasons. Tell me why that should not be in the IEP. So
I think those are excellent tips, because I think so many times parents feel like, that's going to be a roadblock, and they don't know that they can pursue that and ask some clarifying questions or something to keep that conversation going. You don't have to, just agree to whatever they first present to you. Right. Let me look at some other questions. Let's see. Debbie says, my son has progressed really much. I guess hasn't progressed really much either through the years, and he's 18 now, and he's still in school in 11th grade. I don't see a question there, but I thought maybe it's also interesting to talk about, isn't Drew 17 now?
Yeah.
And so this will come back to the 10th Circuit. From reading the school district's letter explaining the case decision, it doesn't seem like the school district is ready to settle out of court. So do you expect that you'll be back in court to, redo this case and see what the decision is?
Right. So, on that, we asked the Supreme Court to vacate the 10th Circuit's decision and remand. And that's exactly what we achieved. That's exactly what the Supreme Court did. Supreme Court is just establishing this higher standard. They're not, their job is not to weigh the evidence or apply the evidence to the standard. That's the job of either the 10th Circuit or it could, go back to the U.S. District Court. And so in a couple of weeks, the 10th Circuit will get a letter, a mandate saying, here's the decision. Your decision has been vacated. Now it's up to you to decide the case using this new standard. And, my expectation is, obviously it's my hope, the 10th Circuit can do, various things, but my expectation is because the 10th Circuit, went into great lengths to discuss the meaningful educational benefit standard, the some educational benefit standard, this merely more than de minimis standard, and they applied this meaningful educational benefit standard that the Supreme Court clearly said is no education at all. It's letting the child sit idly by until he exits out of the system. Even using that vanishingly low standard, the 10th Circuit said this is without question a close case. And why the 10th Circuit flipped a coin and ruled in favor of the school district as opposed to the student whose rights are primarily protected by the IDEA is anybody's guess. But that said, they applied the merely more than de minimis standard. The 10th Circuit considered the evidence and said this is without question a close case. And now on remand, they're getting the signal from the Supreme Court that their standard is no standard at all, and that this is a markedly more demanding standard. And so my expectation is, my hope is that the 10th Circuit will just say, they'll just reverse their decision. They won't analyze anything. They'll just say, parents, you win, school district, you lose, and then we'll be done with this.
Right. Well, as you say, the district has a couple of weeks, I guess, to decide what they're going to be doing. And so do you think maybe by the end of this, calendar year, there'll be a decision by the 10th Circuit, or what would the timeline be?
Yeah, certainly. And it depends on what the 10th Circuit, I guess, decides to do. I mean, this case could be decided on remand in say 3 weeks, or the 10th Circuit theoretically, I guess, could say, well, counsel or parties, we have this new standard here. We never applied that new standard. We want you to rebrief it. Or, the other issue is that this case was tried and the evidence was gathered under this merely more than de minimis standard, which is no longer in effect. And so, what is the court to do with that other than just reverse?
Right. So hopefully that'll happen. And I know we're at the top of the hour here, so I want to be cognizant of everyone's time. I want to thank people that are live with us. Make sure that you tell your friends that the live video will stay up on my Facebook page, Visions and Voices Together, as a replay. And I'll also post it on my YouTube channel, which is under my business name, Collaborative Special Education Advocacy. So either way, you can come back to this live show and watch it as a replay, take notes. And as I said, if you're interested in the ebook that I'll be putting out, you can just type in the comments, yes, and I'll get you the link for that. But Jack, I want to thank you so much for taking your time and helping everyone, understand the decision, what the highlights were, some practical tips that we can use as parents and advocates when we're working with our families. So do you have any final closing thoughts you want to share, Jack?
Sure. No, I appreciate you taking the time to do this, and it's certainly very thoughtful. I mean, an important part of this whole thing is having this discussion, right? That it's not just this sort of cold decision that's being handed down and sort of debated in the courts by attorneys and judges or whatever, but this case sort of fosters this conversation that children, I believe, too often or children with disabilities, I should say, are too often, marginalized, and that this issue as to what substantive rights children with disabilities have with regard to an education is not, one at the top of say the media's conversation or the public's conversation. And I think that it's a discussion that has to be had, and whether you agree with it or you don't agree with it, or people have widely different opinions about it, I do think that it's critical that we all have this discussion and this sort of enthusiasm continues.
Well, thank you. And to remind everybody, we'll be back on our regular schedule this Thursday evening at 7 o'clock Mountain Time. I'll be interviewing Nicole Edricks from the Inclusive class. So I hope you can join us. The month of April, we're going to be talking about inclusion. And so again, I thank you, Jack. Thank you to all our viewers, and everybody take care. Bye-bye.
Thanks.